Good evening to all of you. We now go to the last chapter. As far as the specific contracts are concerned, it is called the law of agency. It is contained from section 182 to 238, nearly 18 plus 38, that is nearly 56 sections. It is the longest chapter as far as specific contracts are concerned. Every one of us require the help of someone in an outside city. For example, suppose you are in Hyderabad, you have got your properties at Ludhiana or Chandigarh. You require the assistance of someone. You can't be going again and again and note the progress of the case. So you require the assistance of a local resident in whom you have got confidence, or who is your relative, or who is your friend. Then you authorize him or empower him and constitute him as your power of attorney, or what they call it in Hindi as a mukhtiar, and authorize him to represent you in all matters before the courts and take care of his property issues before the concerned courts. So, an agent is mostly an intermediary who acts for and on behalf of his boss, that is the principal, and does those acts which are authorized and which is empowered to do it on behalf of another person. In other words, an agency is defined as a person who acts on behalf of the person residing in a different city and transacts business for and on behalf of the principal and a contractual and brings up here in something like, for example, suppose you take a pipe, two pipes have to be joined. Then you require a coupling in the middle, or that has to be connected with a coupling. That coupling is the agent. So, suppose you are residing in this city and you are not able to take care of your property issues or the legal issues and bring actions against the opposite party, then, or you are asked to defend a case which is brought against you, and it is not possible for you to visit that city always and always have monitor the progress of the case, then you appoint a person who is an intermediary in whom you have got confidence, or who is your relative or who is your friend, to act on your behalf on your instructions. And such a person in law is called an agent. An agency arises in various aspects. But please remember, don't be confined to the word agency. Agency also, you have different connotations, different names. Nowadays, they are called dealers, they are called stockists, or they are called C&F agents, and so on and so forth. So, to put it in simple terms, a person who acts on behalf of another person represents his interests, and then he is authorized to transact business and also look after the litigation and look after the property on behalf of another person who stays in a different city. Such a person is called an agent. And the contract which is arrived at between you and that person is called the contract of agency. Then you take your own case. We are all advocates. Please remember, why do you file Wakalatnama, sir? Wakalatnama is a document through which your client empowers you or engages you as his advocate to prosecute the case, to defend the case, to look after the case, and also conduct the case, and also do the cross examination and the arguments. And there, that is the reason an advocate also acts as an agent of the party. Then you take the case of income tax tribunals or the sales tax tribunals or the VAT, so on and so forth. There the wakalat is not filed. What you file is the power of attorney is filed. You give a power of attorney to a chartered accountant or a practitioner who is practicing on the income tax side or the commercial taxes side or the VAT tribunal or various authorities. Then the person whom you authorize to represent you, to prosecute the case, defend the case, look after the case, administer the case, keep you informed about the developments from time to time, and take interest as if it is his own case. Such a person is called an agent. An advocate also sometimes, or why sometimes, most of the times, the power which you derive from a client by filing a wakalatnama under his signature authorizes you to represent him in the court. So, an advocate also is an agent of his client. A chartered accountant or a company secretary also who is given a power of attorney to represent the party before the tribunals concerned is also an agent of the party. Then a branch manager. Nowadays, please remember the institution of managing agency has gone. Now we have what is called every officer of the bank except State Bank of India. They are authorized by a power of attorney to represent the bank wherever they go, sign and verify wakalats, engage advocates, and also give evidence for and on behalf of the bank concerned. And such a person is called an agent of the bank and a person who is authorized to appear, to prosecute, and defend the case on behalf of the bank. Such a person is called an agent. Then we have the petrol bunks. Petrol bunks, we have four major companies. That is the that is the BPCL, HPCL. BPCL is Bharat Petroleum Limited. Then you have got the Hindustan Petroleum. Then we have got what is called the Indian Oil Corporation. And then we had the IBP. Now IBP has been merged with Indian Oil. Then we have got the new companies are coming, SR. Then you have got what's called Nayara. All these companies are what are called. They have their controlling office somewhere, and they are only the agent. They are only the dealers as far as the particular company is concerned at a particular place. Such people who act for and on behalf of the principal who stays somewhere or where the registered office is elsewhere and transacts business for and on behalf of a person residing at a different place, such a person is called a dealer. Then you have got the C and F agent. C and F agent is, for example, you have, let us say, for a particular area, let us say Telangana, Andhra, and Pondicherry and Tamil Nadu, a particular C and F agent is appointed. That C and F agent receives the stocks from the main company and he distributes it among the retailers. And the retailers will have to purchase the goods purchase the product from the C and F agent, and the C and F agent is paid his commission for rendering services. And such a person is also called an agent. And the contract which is brought, and stockist. Sometimes big companies like Cipla, pharmaceutical companies, Sun Pharma, Aurobindo Pharma, then Reddy Labs, so on and so forth. They appoint their own stockist. They stock the goods of that particular company, and then the retailers come to them and purchase the goods, and this man has to sell the goods to them and then maintain proper accounts regarding the sales and regarding the purchases. Such a person who acts as an intermediary, who is a conduit pipe, who is a connecting link between the person for whom he works, that is a principal, and a third party, is called an agent. And the contract through which he gets the authority is called the agency agreement, or you may call it a stockist agreement, or you may call it dealership agreement. Nowadays, you find that a lot of franchises are being given. For example, Karachi Bakery, if you take Karachi Bakery, the head office is at Mozamjai Market. But if you go to every locality, you have a Karachi Bakery shop. Doesn't mean that they're independent people. These main Karachi Bakery people, they grant franchises to different individuals on payment of EMD or whatever may be the terms. And then these people will have to sell the products manufactured by the Karachi Bakery and vend it in their shop. Then you got Pulla Reddy. Doesn't mean that Pulla Reddy's main shop is at Abbott's, but the other franchises are there at different places. Even in the airport, you got the Pulla Reddy shop. These people are all franchises and they act as the agent for and on behalf of the Pulla Reddy Sweets. So, agency is in operation almost in every sphere of activity. No person can transact business on his own, more particularly if he is already preoccupied with his work and he cannot transact the business at a different place. Then he appoints an authorized person who acts as an intermediary on his behalf to do all acts or any of the acts specified in the agreement of agency and transacts business for and on behalf of the principal. And for all practical purposes, the agent is a person who sits in the shop and transacts the business. Even in the Factories Act, A person who sits in the shop may not be the owner, but in the factory act, a person who sits in the shop transacts the business of the factory is called the occupier. An occupier also is primarily responsible as far as the business is concerned. Then we go to what is called the principal should be competent. Please remember, everywhere the specific contracts also deals with its great grandmother. That is the Contracts Act. The Contracts Act, Section 11 of the Contracts Act says any contract with a minor, person of unsound mind, intoxicated person, idiot, or anyone who is disqualified by the law for the time being in force cannot enter into a contract, and such a contract is supposed to be void under Section 11 of the Contracts Act. So, for a law of agency to come, the principal should be competent, and then agent may not be competent to the contract. As far as principal is concerned, who authorizes an agent, empowers an agent, or constitutes an agency, should be competent to enter into a contract. That he must be of the age of majority. He must not be of unsound mind. He must not be an idiot. He must not be disqualified by any law for the time being enforced. So the competency or the principle is involved as far as the law of agency is concerned. But as far as an agent is concerned, agent may be competent, may not be competent, but competency will not come in the way as far as an agent is concerned. Then, sir, he is employed to do anything, any act for another or to represent another in dealings with third persons. The person in whom he acts is a person for whom he acts. Please remember, who is an agent, sir? Agent is a person who sits and transacts business for and on behalf of the person who appoints him as an agent, appoints him as a dealer, appoints him as a stockist, appoints him as a C&F agent, and he does all those acts which is supposed to be done by the principal himself if he was here. So all the acts which are authorized, empowered under the contract of agency, the agent is justified in performing those acts. Then the person who gives the authority, the person who appoints another person as an agent is called the principal. And the person who is appointed as the nominee of the principal to act on his behalf is called the agent. And the contract through which or the agreement through which an agency is constituted is called an agency agreement or a stockist agreement or a dealership agreement or a franchise agreement, whatever terms you may call. And even you as an advocate, you derive your power by the wakalat that is given to you or the power of attorney which is given to you if you are appearing in the tribunals and the other authorities are the so and so. Then suppose, let us say, in a company, you cannot expect the managing director to come to the court every time. In that articles itself, they provide for all practical purposes, the company secretary of the company shall represent the company in all matters and is empowered to give evidence for and on behalf of the company. He is empowered to give instructions to the advocate. He is empowered to give instructions to the advocate how to prepare the cross-examination, how to examine the witnesses, what are the crux of the case, and all the documents will be given to the advocate. And the advocate acts as an agent, and even the chartered accountant or even the company secretary acts as the agent of the company. Then, agent is a person whom he acts for whom he acts is called. Agent is a person having express or implied authority to represent or act on behalf of another person who is called the principal. See, the authority that is derived by the agent may be express or may be implied. What do you mean by express? Express means which is spoken, which is in writing, where the authority is given in writing, where there is an agency agreement, whereby the agent derives his authority to represent his principal for whom he works in all the institutions, in all matters, including legal matters. Such a person is called an agent. An agent is a conduit pipe or is a connecting link between the principal and the third party. He brings about a contractual relationship between the principal and the third party, and he does all the spade work for and on behalf of the principal, and takes care of the business of the principal at all times, looks after the affairs of the principal at all times, looks after the outstandings of the principal at all times, and if any amount has to be paid to third parties towards the contract, then agent is authorized and empowered to pay that money for and on behalf of the principal, and then such a person is called an agent. Then general rules of agency. Uh, a, per- a, what what a person competent to contract may himself may or through his agent, except for acts involving personal skill and qualification. Act for a person cannot marry. Here it is said uh, qualification, like a person cannot marry, turn an agent. A person cannot paint a picture through his agent. Please remember, except when personal skills or experiences required, please remember a barber's trade, a washer trade, or let us say a cobbler can only stitch your, repair your shoes, or let us say different people can do different jobs. A tailor can only stitch clothes, a clothier can only sell cloth. Then, in that case, a personal skill and experience for an advocate is well versed in legal matters. He knows the law, how to interpret the law, how to put the law in a proper perspective, how to draft the pleadings, how to prepare the case, how to argue the matter, how to cross-examine the witnesses concerned, who are the witnesses who have to be examined. All these things is known only to a person who has got personal skill and experience. Suppose, suppose let us say an appendicitis operation has to be done. It involves personal skill and experience, isn't it, sir? Every one of us cannot be a surgeon. Only a surgeon can do it. Then, in that case, a person cannot be appointed as an agent who does not possess a sufficient skill and experience in doing a particular job. He is only employed for the purpose of looking after the business of the principal, acting for and on behalf of the principal, and transacting for and on behalf of the principal, sit in the shop and do the business, collect the outstandings and pay the outstandings, bring about a contractual relationship between his principal and the third party. Such a person is an agent. But when it involves personal skill and experience, an agent cannot be appointed for that particular purpose. Then difference between agent and servant. This is a very crucial question, sir. Here, as far as an agent is concerned, who appoints an agent? Agent is appointed by the principal. Here it is said, a authority to act, bring about a contractual, apart from acting on behalf of its principal, an agent has the authority to create contractual relationship between the principal and a third party. Here, what does the agent do? He acts for and on behalf of the principal. He transacts the business for and on behalf of the principal. He collects the money for and on behalf of the principal. He sells the goods for and on behalf of the principal. He collects the outstandings for and on behalf of the principal. He pays the money, whatever is due to the third party on behalf of the principal. All these acts he is authorized to do. But a servant, and please remember, an agent is always answerable for his acts to the principal. But as far as a servant is concerned, servant is bound to work under direct control of the employer. The principal directs the agent as to what is to be done. But a master or employer or servant not only has that right, but also the right to direct how it has to be done. See, normally a servant is employed for the purpose of doing household work, laundry, washing, then washing the floor, mopping the floor, sweeping the floor, and then washing the clothes, so on and so forth. He is always under the control and supervision of the master. He acts as per the directions of the master to do the household work. He is not an agent. Who is an agent? An agent is a person who is authorized, empowered by the principal to do all acts and deeds for and on behalf of the principal under the directions of the principal. So, an agent is someone different and a servant is someone different. An agent is responsible only to the principal. But as far as the servant is concerned, He is responsible to his master, and he has to act according to the directions of the master, and is appointed only. Sometimes what happens is, if old people are there, the servants are employed to look after the old people in the night or in the daytime. Why? Because sometimes they may not be able to walk. Sometimes they may not be able to go to the toilet personally. They have to be taken physically to the toilet to answer their calls of nature, or they require massage from time to time, or they require personal there is personal supervision or personal assistance at all times. And please remember, for all the services which a servant does, he is remunerated by payment of wages or payment of salary every month or every week or whatever it is. But an agent acts for or on behalf of the principal. He does those acts which are empowered, which are directed to be done. And for all practical purposes, an agent is a person who represents the principal at a particular place. He brings about a contractual relationship between the principal and a third party. And a classic example can be given is, in the case of companies, before the incorporation, the persons who are the foremen, persons who are responsible for floating a company, they are concisely called promoters. Please remember, a company is not born in a day. Lot of work has to be done. Project work has to be done. Survey report has to be done. Viability report has to be done. The process, the question of the availability of the product. What is the type of product which they are going to manufacture? How it is going to be sold in the market? Who are going to be the potential purchasers? Who are the persons whom you can rely? Who are the persons who can honor the contract? Who are the persons who can purchase from you? And that particular product, is it manufactured by any other rival company? Then what is the price at which they are offering it? And what is the price you are going to offer it? So these are all the preliminary work which is done by the promoters before the incorporation. For all practical purposes, though the company is not born on the day when they enter into this pre-incorporation contracts, they act as agents for a company which is going to take its birth. But as soon as the company is born, these promoters are made the first directors of the company, so that the contractual obligations which are arrived at by the promoters pre-incorporation, they can be honored, they can be respected, they can be implemented. And that is the reason the confidence is built up among the third parties also, who will place orders with your company. So, in other words, if even the promoters before the incorporation act as the agents of the company concerned which is going to be born, and they go to the chartered accountant, get the memorandum of association prepared, articles prepared, prospectus prepared, share. All these things are preliminary, and also liaise with the company, liaise with the registrar of companies. We take the required forms, and they fill up the required forms, and they take all steps possible for the company to take its birth. So these people are also these promoters also act as agents of a company which is not yet born. And as far as the servant is concerned, servant has nothing to do except to do the household work, laundry work, washing work, mopping work, sweeping work, and other works, or gardening work, whichever is, or take the children to the school, get them back, or drive a vehicle, take the children, so on and so forth. He is paid his salary, he is paid his wages for the services rendered. He is always under the control and supervision of the owner for whom he works. Here, number of masters. A servant may serve one master, please remember, but agent may act for several masters. See, as far as a servant is concerned, please remember, it's only a myth. A servant who is your domestic servant may be working in different houses as a maid servant. She may be working in different houses. What payment you make may not be sufficient for her, yeah, getting on in life, but she serves different masters. But as far as an agent is concerned, agent agent can serve various masters also. You can be an agent for one company, you can be an agent for another company, you can be an agent for, like that. You can have multiple companies for which you can act as an agent. As far as the remuneration part of it is concerned, a servant is paid only his salary, only his wages. for the services rendered. But an agent, uh, but but an agent generally gets his remuneration through the terms of the calculated on the basis of the amount of business transacted. Please remember, these agents, they have got a certain target. Once they achieve that target, 5% or 10% of the sale proceeds which they get, they are paid towards their commission. It depends on the contract between the principal and the agent, and then their targets are fixed. Once the target is achieved, according to the achievement of the target, the commission is paid to the agent for the services rendered, or the remuneration is paid to them. Then the duty assignment. So a servant, in certain cases, to some extent, may be assigned the duties of an agent and may act as one. Example: secretary of a company is a servant of the company. The task done by the servant includes housekeeping, cleaning, laundry, washing clothes, and arranging tables, etc. Here, sometimes what happens is the servant also acts as an agent. What he does is his job is may be assigned from the duties of an agent and act as one. Suppose, let us say, the boss says, please take this electricity bill, please take this municipality bill, please take these payments which I have to make. You make the payments. And there, the servant has to do those duties which are assigned to him from time to time, or take my car and fill petrol and then get it, or fill the fuel and get it, check up the pressure of the tires and all. And sometimes what happens is these people, that is the servants, also act as agents, but not in all cases. A secretary of a company is a servant of the company. Secretary of the company means a PA, a PS or personal secretary, or a company secretary, or a director, or an executive director, or people of different designations. They are supposed to be the servants of the company, and they have to do certain jobs which may not be within their ambit, but still they are assigned to them by the board resolution. And in those cases, they act as the agent of the company. Here, the tasks done by the servant excludes includes housekeeping, cleaning, laundry, washing clothes, and arranging tables, etc. An agent acts on behalf of the principal in legal matters or transactions. Please remember, for all practical purposes, the principal acts through his agent, and once the agent is employed, the agent represents the interests of the principal before all authorities, including the legal authorities, or before the tribunals, or before the various authorities. He also appoints advocates, engages legal counsel, or takes advice from them from time to time, and also do the necessary spade work for taking care of or protecting the interests of the principal. For all practical purposes, he is the key man to go to as far as the principal is concerned. Then he can represent the principal and make decisions or perform tasks within the boundaries of his authority. They are entrusted with the authority to act in the best interest of the principal and fulfill their obligations faithfully. Please remember, sometimes the reputation of the company, reputation of a factory, reputation of a shop, reputation of a business enterprise depends upon the person who has taken the agency from his principal. And he is the person who acts as a conduit pipe or the connecting link between the principal and the third party. He brings about a contractual relationship, and then he enters into contracts for and on behalf of the principal for the benefit of the principal. He acts for the benefit of the principal. For all practical purposes, he sits in the shop and transacts business what the principal would have done himself personally. So here it is said that most of the obligations which are there is performed by the agent faithfully in the best interest of the principal for the benefit of the principal as per the authority that is given to him under the agency agreement. Servant is a person performing domestic duties for another who hires him. The master or employee is a person to do household work, so works as a personal attendant to the master. In simple terms, any person who works in the service of someone else who is particular in the household is a servant. That is, a servant is employed to extend help to the master and work on his command and supervision. As far as the servant is concerned, is subject to the control and supervision of the master, and then he performs such duties which are assigned to him from time to time. Essentially, he does only the household work, washing clothes, laundry, and then arranging the tables, and then doing all the household chores, or he even takes his children to the school and then gets them back. He also drives the vehicle of the master and also undertakes certain work. And for all these things, he is paid, he is remunerated, he is compensated, but he is always under the control and supervision of the master. That's why they say her master's was HMV. That means whatever the master says, Jihan, Mundi Ilana. That is the job of a servant. But a servant cannot be an agent for all practical purposes. But sometimes what happens is the servants become agents. They pay the bills. They sometimes what they do is they act in emergency situations. In that case, they become an agent. But normally, a servant cannot be an agent. Servant is always under the control and supervision of the master, and he performs those tasks which are assigned to him from time to time. In simple terms, any person who works in the service of some, then sometimes what happens is, I have seen near my house, we have got these gated communities where what happens is both the son and the daughter get married, they go away to states, and their siblings, they are left with the old people. For the benefit of the old people, what they do is they purchase a 3 bedroom flat, they engage a servant for 24 hours. The servant has to take care of the old people day and night, and also provide, also cook for them, and also give them the, and if they have to be taken for a walk, they have to be taken for a walk, and also help them in walking and going to different places, and even sometimes drive the car for the old people. And the siblings are left with the old people, and they are act as caretakers. And so that's the reason. Sometimes what happens is these servants are appointed for a particular task. And there are people who remain throughout in 24 hours taking care of the old people. This is very, very common in these days where money is the only criteria. And please remember, every month they send the money and that is expended, and even the salaries are paid to the servants directly by the children. Then we go to section 183. Capacity of any person to enter into a contract or to do any other act by means of an agent is coextensive with the capacity to enter into contract and to do that act himself. So whatever acts can be done by the principal, they can be done by the agent. And whatever acts and deeds are done by the agent under the control and supervision of the principal, and then whatever business is turned out by the agent on behalf of the principal, or whatever contractual relationship is brought about by the conduit pipe, that is the agent, for the benefit of the principal, binds the principal part. One important thing under section 183 you must remember is that the person who employs who constitutes an agency should be competent to enter into a contract. He must be of the age of majority. He must not be of unsound mind. He must not be an idiot, or he must not be disqualified by any law for the time being in force. But an agent need not be competent to contract. And even a person incompetent to enter into a contract also, he can be appointed as an agent. Then, sir, we go to 184, permits a minor as well as a person of unsound mind to become an agent as between the principal and third parties. There may be cases where an agent may incur a personal liability upon the contract towards third parties. Then here it is said there is no when you say in the law of partnership, a minor cannot be appointed as a partner, isn't it? He is incompetent to enter into a contract. But there is an exception made in the Partnership Act that a minor can be admitted into the partnership firm, but he can be admitted only to the extent of the profits of the business. He is not liable as far as liabilities are concerned. And once he attains the age of majority, then alone the minor has got a right of either electing to remain as partner or to retire from the firm. And when he retires, whatever liabilities are incurred during his minority, he is excused. But as far as the liability, suppose he elects to remain as a partner, the liabilities he is liable to contribute towards his liability. But as far as the law of agency is concerned, the principal should be competent to enter into a contract, but an agent need not be competent to enter into a contract. A minor or a person of unsound mind also can be appointed as agents. But if any deficiencies arise, any liabilities arise between the principal and the third party, when these agents perform their respective duties, the principal alone is responsible. The agents are not responsible in any manner. That's what 184 states. Then we go to 185. 185 is consideration is not necessary for creation of an agency. What is section 2 clause D of the Contracts Act say? Any contract without consideration is nullity. It's a nudum pactum. It is unenforceable under the law. But as far as law of agency is concerned, consideration is not the criteria. Only thing is conducting the business for and on behalf of the principal who is in a different place is the only consideration. Money need not be paid. You need not pay money to get an agency. But of course, nowadays they're charging franchise agreements and all. They ask you to deposit the EMD also. But to create an agency, consideration is not necessary. That's what Section 185 says. Then 186 is the authority of an agent may be expressed or implied. Then next section says authority is said to be expressed when it is given by words spoken or written, and authority is said to be spoken or written in the ordinary course of the dealings, may be accounted circumstances of the case. So, as far as the authority is concerned, it can be oral, it can be in writing also. Once it is in writing, it's called an express authority. But once it is understood from the circumstances of each case, facts of each case, the situation scenario which arises from time to time, then it is said it is supposed to be implied. So the question is, normally agency agreements, stockist agreements, dealership agreements, franchise agreements, to be on the safe side, it is reduced to writing because the question is, it is for the safety of the principal and safety of the agent. So with this, we have finished up to 186. The rest of it, that is from 187 to the other sections, we will deal with it because this is the biggest chapter as far as the law of contracts is concerned. I would like to go a bit slow so that you understand it properly. And any doubts you have got, please try to clarify it in the same class or the same lecture when we are having the lecture, please. Don't try to have lingering doubts in your mind. Don't confuse yourself because we are all professionals. We don't require spoon feeding, but naturally, sometimes also doubts arise. Please try to clear it as early as possible. Today, we thought of going through the law of agency because I'm really disappointed by the attendance in the Zoom class. If the attendance improves, the question is we may think of implementing the 3 days YouTube and 3 days Zoom class. But any doubts you have got from the previous classes, please try to clarify it. Now the house is open for interaction, please. Any questions? Please remember, if you don't ask questions, it means that you are having doubts in your mind, but you're feeling shy of asking it. Please don't be shy.
Sir, hello. Good evening.
Yes, Nokia.
సార్ నాకు ఇంతకు ముందు నేను మీకు అడిగినా నాకు అర్థం కాలేదు కానీ నేను మళ్ళీ అడిగితే మీరు తిట్టద్దు సార్. అది రిపీల్ అయిన సెక్షన్ మీరు ఫస్ట్ క్లాస్ లో కాంట్రాక్ట్ లో చెప్పారు. సెక్షన్ 72 టు సెక్షన్
76 to 123.
ఇంకా
239 to 270.
270 270.
Ama 270. 239.
76
to 123.
123 సార్. ఈ సెక్షన్ ఇప్పుడు ఎన్ఫోర్స్మెంట్ లో లేదు, రిపీల్ అయిపోయింది.
That has now been included in an enactment called Sale of Goods Act. And ఇంకోటి 239 నుంచి 270 కి ఏదైతే ఉందో అది పార్ట్నర్షిప్ యాక్ట్ లో ఇంక్లూడ్ చేశారు.
అచ్చా సరే సార్. థ్యాంక్ యూ సో మచ్.
వెల్కమ్.
All right. See you tomorrow again. Bye bye.